Sure. If you'll bow with me. Father in heaven, we just come thanking you for this time of us being together, Lord. We just thank you for a fresh start, Lord, and we just ask that you would lead the steps of this meeting, Father, and that everything we do be according to your will, Father. We just thank you for your protection last night during the storms, Father. We just thank you for no one getting injured or hopefully no property damage, Lord. And we just ask that you would lead and guide and direct in all that we do, and we ask that you forgive us where we fall short. In Jesus' name we pray. Amen.
Amen. Commissioner Barrett, would you lead us in the pledge, please?
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to call the meeting to order, Marsh County Fiscal Court, January 3rd, 2023. Move over. Our first guest will be Chrissy Greer, Marsh County Clerk, with her budget. And annual order setting maximum amount of salaries for deputy clerks and assistants. And I think, Commissioners, you all have had a chance to review that. Does anybody have any questions for her? I'll need a motion for each.
I make motion.
To approve.
To approve.
Need one for each of those, Jason?
I think you have to have a separate one.
Separate.
Yes.
Separate motion.
All right, I'll make a motion that we approve the 2023 Marsh County Clerk's budget.
Second.
In discussion? All those in favor?
Aye.
Motion carries.
And then I'll make a motion that we approve the 2023 annual order setting maximum amount of salaries for deputies and assistants for the Marsh County Clerk.
Do you have a second?
Second.
Any discussion? All those in favor?
Aye.
Motion carries.
Thank you.
It-
Look
thank
forward
you.
to working with you guys.
It will not
Thank you.
always be that
look,
easy.
No, I like it. You did the talking
But-
for me. This was great.
We'll let you off easy.
This time.
You didn't
we're
have to
letting you-
explain anything.
She explained it before. I did have some questions and she answered
Oh,
them.
I
so,
bet he did.
Yeah.
Okay, under correspondence, Commissioner Collins is going to read the governor's proclamation and congressional record.
All right, we'll start with the proclamation. Judge Spraggs and I think, Matt, I think you, I don't know who all was there from the court that was at the Marsh County Long-Term Recovery Group. I had an event honoring those that survivors of the tornado a couple of weeks ago, and so Governor Beshear was there and gave us this proclamation, and so I'll read it. Proclamation by Andy Beshear, Governor of the Commonwealth of Kentucky, to all to whom these presents shall come. Whereas on the night of December the 10th, 2021, severe storms swept across the Commonwealth, spawning several deadly tornadoes that brought incredible devastation to many communities, especially across the western part of the state. And whereas the Kentucky towns of Mayfield, Dawson Springs, Bremen, and areas of Princeton, Benton, and others were nearly wiped off the map by a single large, long-tracking tornado that was on the ground for several hours and more than 165 miles crossing the state. Two separate tornadoes did incredible damage in Bowling Green as well, and whereas these devastating tornadoes killed at least 81 Kentuckians and more than 500 Kentuckians were injured. This was the worst tornado outbreak in Kentucky's history. Disaster declarations included the counties of Barron, Breckenridge, Bullitt, Caldwell, Christian, Fulton, Graves, Grayson, Hart, Hickman, Hopkins, Logan, Lyon, Marion, Marshall, Meade, Muhlenberg, Ohio, Shelby, Spencer, Taylor, Todd, and Warren, And whereas, even though the tornadoes left behind so much destruction, the human spirit, and particularly the spirit of Kentuckians, could not have shined brighter in these days, weeks, and months following the disaster. People from across the United States and around the world also generously donated their time and resources, with many people traveling to the hardest hit areas to help in the recovery efforts. And whereas it is the duty of the Commonwealth to remember December the 10th for the massive destruction of these devastating and deadly tornadoes, and to honor those Kentuckians who lost their lives. It is also a time to remember and celebrate the many first responders and civilian heroes who worked tirelessly throughout this year following the disaster. Now, therefore, I, Andy Beshear, Governor of the Commonwealth of Kentucky, do hereby proclaim December 10th, 2022 as Western Kentucky Tornado Remembrance Day.
Thank you. I want to commend our Parks Department and our Road Department for putting together awesome floats for the parade also. We appreciate that. The community appreciated it, appreciate everything everyone has done.
All right. Congressional, sorry. We also have the congressional record that was put in by Senator Rand Paul in the Senate and read in Washington on Monday, December the 5th, the anniversary of tornadoes in western Kentucky. Almost 1 year ago, on December the 10th, 2021, multiple tornadoes touched down all throughout western Kentucky, including one historic supercell tornado that affected multiple states and ended in Kentucky. Lives were upended as homes, businesses, and towns were completely destroyed. In many places, the destruction was total and absolute. At a time when families were to be preparing for a joyous holiday season, they were instead greeted by sorrow and loss, while being surrounded by an uneasy reality of wreckage and despair. Immediately, local citizens, Kentuckians around the Commonwealth, and people from across the country converged on Western Kentucky to help in any way they could. Disaster relief teams sprang into action to meet the needs of those who were impacted and who had lost everything. I'm grateful that Kentuckians rose up in the face of this crisis to do whatever was necessary to help and to provide care for our neighbors. While outside organizations and ministries provided essential services, the real heroes of the story are the communities themselves that were destroyed by the tornado. Through this historic crisis, the men and women of Western Kentucky have demonstrated resilience and compassion as they care for the communities they call home. From the first responders to the local officials, to each man, woman, and child involved, there was remarkable strength demonstrated in the face of adversity. Communities have grieved together, served together, hoped together, and rebuilt together. Today, almost 1 year later, we look back on what had been lost, but also to resolve to look forward to what can be achieved together. As we pause to reflect on the destruction of December the 10th, 2021, we can see the hope that now shines through as towns are rebuilt and communities regain shape. Even in tragedy, Kentucky has shown itself to be resilient and unified. We will continue to press forward and care for our communities. And that was read into the record by Rand Paul, one of our United States senators.
Thank you, Monty. Under old business, can I get a motion to approve the minutes from the December 20th meeting?
So moved.
Second.
Any discussion? All those in favor?
Aye.
Motion passes. Chad McCann's here. I was going to ask Chad to come up and just give us a brief update, and if anyone has any questions for him.
Good morning.
Good morning.
Don't have a lot of specifics to add today, but I did want to be here in case anybody had any questions about our ongoing work that we're doing in the city of Hardin on a couple of water projects in Calvert City. If you got any questions on that, Monty, or the Oak Level water projects that we're working on over there. Update on the Hardin water projects. The contractor plans to start on that work this week, moving materials and equipment into the site, and they should probably start earnestly digging next week, excuse me, on that project. So expect that project to last 4 months to completion of it. So by this summertime, those services and the water line should be in service over there in that area on the Hunter Road and Walnut Grove Road water projects. On the other projects that we're working on in Oak Level, we are working through the design. We sent our first batch of easements over to the City of Benton's attorney for review before we start contacting those property owners. It accounts for about 50% of the design work on the project that we're working on right now. So as we get the surveys in, we've gotten, I think, 90% of our surveys completed on that job, and we're working through those designs, final designs on those projects right now. So as we work through those, we'll get them done, and then we'll continue to update you all on our progress with the design and easements and permitting. And as we get those completed, then we can talk some more about how we may want to procure that work and start getting some of those water lines constructed this year. As far as the PB Cloud Road project, that is a city project now, Calvert City project. They had been awarded the grant monies for that project. We're starting design work on that project and expect that to move pretty quick here this winter and spring.
Okay. So, and that'll be a much shorter time frame than Hardin project, right? Or
On the
would it
Calvert
be?
City project?
Yeah.
Likely. It will be an easement project as well, so some of that is a bit of an
I
unknown
gotcha.
when we get into that, but most of the time, it goes pretty quick when people are wanting the water.
Yeah.
Area.
Yeah. Okay. Okay.
Any questions for any of the commissioners or anybody that may not have been plugged in on the front end? All right. Well, I
Thank you,
appreciate
Chad.
y'all's time.
Appreciate it.
You're very welcome. Thank you.
Thanks, Chad.
FSA contribution, resolution, and agreement. I'll ask Andy if he'll read that, please.
Okay, this is reflective of IRS changes. So here we have an amendment to Section 125 of the flexible spending arrangement. It allows increases in the annual maximum contributions and an increase in carryover. So whereas the Marshall County Fiscal Court, herein referred to as the employer, previously established the Marshall County Fiscal Court Section 125 flexible spending arrangement, hereinafter referred to as the plan, and whereas the employer wishes to amend the plan to allow for an increase in the FSA annual maximum contribution limit of $3,050 beginning January 1st, 2023, and that the provisions within this amendment pertaining to annual increases in the FSA maximum contributions are allowed to stand as a valid amendment for automatic increases for future plan years beginning January 1st and ending December 31st. And whereas the plan allows for a rollover option, wherein FSA participants may roll over $610 or less into the current plan year at the end of the plan year, and after any run-out period has been completed. And whereas the employer wishes to amend the plan to allow for the current annual rollover increase of $610 or less beginning January 1st, 2023, and that provisions within this amendment pertaining to annual increases in the FSA maximum rollover are allowed to stand as a valid amendment for automatic increases in the rollover amounts for future plan years beginning January 1st and ending December 31st. And whereas the employer has the authority to amend the plan and undersigned has the authority through resolutions adopted by the Board of Directors or other persons of authority to execute this amendment on behalf of the employer. It is therefore agreed that the FSA plan year beginning January 1st, 2023 shall provide for an annual contribution maximum per employee of $3,050. Each subsequent plan year beginning January 1st and ending December 31st shall automatically provide eligible employees with the opportunity to elect the annual maximum contribution as determined by the IRS and based upon the rise in the Consumer Price Index. A carryover of $600 or less of unused FSA funds after the run-out period ending March 31st may be used to pay or reimburse medical expenses under the health FSA that are incurred during the entire plan year to which it is carried over. The rollover option shall be effective for the plan year ending December 31st, 2023, and applicable to subsequent plan years beginning January 1st and ending December 31st, and shall automatically provide eligible employees with the opportunity to roll over the maximum rollover amount as determined by the IRS and based upon the rise in the Consumer Price Index. Rollover funds shall not be included in the annual maximum contributions allowed for any plan year. The plan is amended in accordance with Revenue Procedure 2022-38 to allow for an increase in the FSA annual maximum contributions of $3,050 to provide for the carryover of $610 or less of unused FSA funds at the end of the plan year and after the run-out period, to be effective January 1st, 2023, and provide for automatic increases in both the annual maximum contributions and rollover amounts for consecutive plan years beginning January 1st and ending December 31st.
Do we need to approve
Yeah, could I
that
get
or
a-
the resolution,
We need to
or
approve
both?
both of them. Could I get a
Separately?
motion to approve the amended FSA agreement?
So moved.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Motion carries. You'll read the resolution, please.
All right, here's the resolution. The undersigned authorized representative of Marshall County Fiscal Court, the employer, hereby certifies that the following resolutions were adopted by the employer on January 3rd, 2023, and that such resolutions have not been modified and rescinded as of the date hereof. Resolved that the amendment to the Marshall County Fiscal Court flexible spending arrangement presented to this meeting is hereby approved and adopted, and that the duly authorized agents of the employer are hereby authorized and directed to execute and plan to the administrator of the plan as one or more counterparts of the plan. Resolved that the administrator shall be instructed to take such actions that are deemed necessary and proper in order to implement the amendment, and to set up adequate accounting and administrative procedures to provide benefits under the plan. Resolved that the duly authorized agents of the employer shall act as soon as possible to notify the employees of the employer of the adoption of the amendment by making a notice available to each employee in the form of the summary of material modification presented to this meeting, which form is hereby approved. The undersigned further certifies that attached documents are true copies of the amendment and the summary of material modification approved and adopted in the foregoing resolutions.
Do you get paid per word, Jason, on that? Just as a, could you answer that for our folks?
I didn't write that. I
Oh,
didn't
okay.
write that.
All right, just checking.
Do I have a motion to approve the amended FSA resolution?
So moved.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Motion carries.
That's all right.
Brittany, would you come up and tell us a little bit about the Rocky Point boat ramp situation, please?
So, as you all know, or most of you probably know, the Rocky Point Day Use Park was used for the water debris recovery after the tornado. We did just get the boat dock replaced out there using the safe funds for wet debris. Once the water went down to Winter Pool, we were able to see the full extent of the condition that the ramp was in. And basically the end of the ramp, that whole concrete section came dislodged and it's out in the water some more. So that ramp is basically useless at this point. And so we started the process of trying to get this fixed. I spoke with Laurel, and she said that we can replace that ramp using safe funds for wet debris. So we do have that there. Talked to Erica about that. The only thing with this is the current ramp is a 15 by 67 ramp. Honestly, it's not really large enough for the amount of traffic that we have at that day use park. So we looked at our TVA permitting that we already had in place. We're actually permitted at that location for a 30 by 70 boat ramp instead of a 15 by 67. So the TVA permit already covers us having a larger ramp than we currently have. The only issue there is not currently approval or a permit in place from the Army Corps. And because we are going to expand that to that 30 by 70, we need the updated permit from the Corps. We have applied for that permit. The only issue there is that it is about a 60-day waiting period to get a permit approved from the Corps. Other than that, we're ready to go. The road department can do the work. Thankfully, Senator McConnell's office, Morgan, has been wonderful. They're trying to help us. They've got their DC office involved. They are reaching out to the Corps. Morgan is going to keep me updated, and hopefully we're going to be able to get a quicker resolution to that issue from the Corps. As long as we can get that stamp of approval on moving forward, we'll be good to go there. The SAFE funds will only cover the portion of the total that would have replaced the current ramp. So that 15 by 67, whatever amount that would have cost is the portion that we can expense to the SAFE funds. The rest of the difference, which that would be the largest portion of it, honestly. You're going 3 foot farther out and 15 feet wide, but the majority of that can be covered through the SAFE funds. So if we do want to move forward with expanding that ramp, then we would need to come up with that difference between the two. Roy is working on estimates for that project. Don't have a hard and fast answer for an exact amount yet. They are going to bring in one contractor to do part of that, correct? Yes, and then the road department will be able to do the rest of the work. So I believe you said 30,000 is what we would like to request, just to make sure we have more than enough to cover anything that could come up. But like I said, I don't foresee it going that far at all, because the 15 by 67 portion of that can be expensed to the SAFE funds.
So,
Go ahead.
so the 30,000, we've talked about this, but I don't know if I know the answer to that. So is the 30,000 the total, or is that for the 15 by 3 foot difference?
$15,000 to replace
To
the
add?
ramp as it is now.
Oh, okay, okay,
And you can pretty well figure another 15 to add another 15
okay.
foot by 70.
Okay. So 15, so approximately half of it will be covered by the SAFE funds. The other half is on us.
Would be on the county, correct?
Okay.
Yes.
30-foot gives us adequate room for 2 trucks and trailers to back in at the same time, and it really expedites things at the ramps, because it seems everybody shows up at the same time and goes home at the same time. So I fully support that. Our road department will be doing the work, and if you haven't been out to the ramp at Big Bear, I would invite you to go out there and look at it. They did a fabulous job on that, and we're just, kind of in a time crunch on this, because we have to do this during winter pool. So hopefully everything will come together on that.
And I'll also add too, when I spoke with Laurel, we don't have just an endless amount of time to be able to access those SAFE funds. She said the sooner the better. Really, this was probably a month ago we started working on this, I'm going to say at least a couple weeks ago. And at that point, she said a month or 2 to be able to still turn projects in for those SAFE funds. So that's another reason it becomes even more important that we don't get hung up in a 60-day waiting period with the Corps, because we could potentially lose access to those SAFE funds to be able to fund the project, or at least close to 50% of it.
So thank you to Senator McConnell's office, and I think Congressman Comer's office has been in contact with them maybe also.
I've
think
just
so.
spoken with Morgan
I
about
think
it.
yeah.
So far.
But, man, that I don't understand the Corps and how they're even involved in Kentucky Lake.
I honestly
project.
was unaware
I
that
don't
the Corps
understand
would
that.
need to be
Yeah,
involved,
me
since we
neither.
already had the TVA
And
permitting.
Real
makes-
estate, 25 years, I've never
Right.
seen them involved on Kentucky
No sense
side.
whatsoever, but it is what it is.
Yeah.
And that's why we have senators and congressmen who have been in office long enough to
Yes.
help
And
us out.
I'll also say that from everything that I've gathered, there's not a mandated 60-day waiting period. It's just
It's
they
just-
say
it's
it will
just
take
them.
them 60 days to look at the application. So
Yeah.
hopefully that's going to be rectified, and we'll be able to get that rubber stamped and be able to start work on this
I waited
way sooner.
13 months one time on
You know, if we
them,
could, if
but-
we could start on this today, say they could go in there and tear it out, and while we're waiting, but we can't do that. We have fishermen, commercial fishermen, recreational boaters, duck hunters, we have everyone relying on that, so we have a limited amount of time we need to get in there and get the job done, so
Exactly.
unfortunately, we're gonna have to wait, until we get that, so.
Are they able to use the ramp right now?
It's usable, it's in really
Sketchy.
bad shape. Yeah.
Yes.
Roy, do we do the site prep and then just hire somebody to do the concrete, or we do the concrete too?
The last boat ramp at Big Bear, we done everything.
Okay,
This boat ramp, we're gonna look at it a little different, being as we're getting a little money, is, looking at a contractor coming in with the GPS to do the grade work underneath the water.
okay.
But that's pretty hard to do underneath the water.
Mm-hmm.
And then, just to throw that out there, any boat ramp in the future or this one, just because you want a longer boat ramp, don't mean that you can get it. You gotta go with the contour, you gotta go with what God give you under the water.
Yeah,
Not necessarily can you say, I'm putting a 70-foot or a 80-foot boat ramp in here. You gotta do what
So even with this one, we don't know. I mean, we know that it was 67 before, so you're talking
Three more foot.
3 foot
Yeah.
I'm pretty sure we can get.
on this one.
70-foot one in there.
Yeah.
Actually, we're permitted to go to the elevation of 351. That's what we're permitted to do. I have to go off of the elevation. not
Yeah.
just the length.
Gotcha.
So of the 30, we will get roughly half of that reimbursed if we get this done in a timely manner.
Yes, fingers crossed. And I think that's the biggest part with allowing for the 30 is just in case this permit doesn't come through from the Corps. In that situation, then we would be on the hook for the full 30.
So as it relates to the safe fund, I know the legislature passed something last year, I think during the special session, maybe for the floods, that extended the Safe Fund Act, or at least when you could use that money. Is Laurel saying that we still have to wait on the Corps even to submit the request?
So the
In this
way the
partic-
safe funds are set up now is we just essentially put them in VIP just like any other expense.
Okay.
So really, I can't submit an invoice or anything for that until we're actually doing the work because I can't put anything in VIP until, until we're doing it. So that's the other part of the hang-up.
All right. So is the other thing maybe that we need to know is if for some reason this doesn't happen on the federal level, then I guess we need to be calling our state legislators and saying, okay, is there anything that you can do to help out? Or the governor's office especially to
Yeah. And-
extend this particular
Yeah.
time frame because we're having to wait on,
And I can go ahead.
surely they
and
understand, waiting on the.
Proactively, I can go ahead and touch base with Laurel, get some definitive guidelines on an actual end date to find out what kind of hard deadline we're actually working with.
Okay.
And then I can go ahead and reach out to the governor's rep and some of the other offices and start working with their reps as well to go ahead and have a united front in place when and if that situation does arise.
Yeah, okay.
I'll go ahead and put all that in place.
Sounds
well.
good to me.
Any other questions for me on the ramp?
All right, I got an ignorant question. Does that money come out of the parks budget, or does it come out of the road department or general fund, or how does that work?
If it were a budgeted project that we had planned for, we would have budgeted that money into the parks
Okay.
funds, yes. Same, it really could have gone either way, into the road department or the parks, but typically we would have done the parks and they would have sent us their invoices for that. In this situation, it's not anything that we had planned for, so
Okay.
we'll have to find the funds elsewhere
Okay.
to put into the park budget.
I'm assuming the county has something set aside for stuff like that.
I'll let Erica elaborate on that.
Sorry, excuse me.
Yes, so we have a budget amendment today that we're reading to bring into our budget excess carryover from the prior year over what we budgeted to have from carried over from one year to the next. And my assumption is that the court will use that pool of money.
Okay.
if y'all have any other questions about it, feel free to holler at me, and I can keep you all posted as we work through this process and after I talk to the reps from the other elected officials' offices, and we'll just get everything in place in case of a worst-case scenario, but hopefully we'll be able to get that approval and we can get started.
Okay.
Thank you, guys.
Thank you.
Do I have a motion to approve up to $30,000 for that Rocky Point boat ramp project?
Do you need anything as it relates to where it's coming from in there as well?
Not at this time, because technically it won't exist in the budget
Right.
until we have a second reading of our budget amendment. So
That's true.
Not at this time.
All right. I move that we approve the project to replace the Rocky Point boat ramp and extend it from a 15 by 67 to what we're permitted for, which is a 30 by 70, up to $30,000 in costs.
Have a second?
Second.
Any discussion? All those in favor?
Aye.
Motion carries. Elena, would you like to speak on these two ordinances real quick? I know we've been working on these for a while, and then I'll get Andy to read them, and we'll get through our first reading.
Yep.
Thank you for being here today.
Oh, of course, my pleasure. Thank you for having me. So these are the two ordinances that we've been working on for the last couple of months that reflect the changes that happened in the last legislative session with House Bill 8. So they updated the transient tax language in House Bill 8 that now requires additional entities to collect all applicable taxes, which include our local transient tax. So the first ordinance on there, I believe, is the short-term rental ordinance. This one is just a registration process for short-term rental owners. Just because we just have so many of them, it'll help us keep better track of who in Marshall County is actually actively renting out their home as a private rental. Now that the new language actually puts the liability of the transient tax collection on the hosting platform. This ordinance, I don't expect us to have to utilize it except for the fact that we just want them to register so we can maintain that relationship. But if for any reason something changes and the liability falls back on the property owner, we have an ordinance in place that can actually help us enforce things if it gets to that. So if there's no other questions about this one, if we want to read that one.
Anybody have any questions?
Buckle up.
I'm sorry.
I did write this one.
Better question is, do I
Next
get,
two.
do I
No
get,
wonder now this one's
get
5
paid by-
pages.
do I get,
huh?
yes,
Don't know if
Obviously.
he gets paid.
do I get paid by the word? That's
Yeah. We haven't even approved you being an employee yet, much less. So right now you're free.
kind of get the message. Okay. All right, this is ordinance 2023-01. It's an ordinance providing requirements for the operation of short-term rentals within Marshall County. Whereas, the purpose of this ordinance is to promulgate rules, regulations, and licensing for certain standards, requirements, and safety measures to ensure the health and safety of Marshall County residents, property owners, and those persons visiting Marshall County, while ensuring that all lawfully owed taxes are remitted to the relevant taxing agencies. Now therefore, be it ordained by the Fiscal Court of Marshall County, Kentucky as follows. Section 1. The following words, terms, and phrases when used in this ordinance shall have the meanings ascribed to them in this section except where context clearly indicates a different meaning. Director means the director of the Marshall County Tourist Commission doing business as Kentucky Lake Convention and Visitors Bureau. Host means any person who is the owner of record of real estate property or any person who is a lessee of real property pursuant to a written agreement for the lease of such real property who offers a dwelling unit or portion thereof for short-term rental. Hosting platform means a person or entity that provides a means through which a host may offer a dwelling unit or portion thereof for short-term rental use. The term hosting platform includes online travel companies that offer dwelling units or portions thereof for short-term rental use. Most platforms are internet-based and allow a host to advertise a dwelling unit as a short-term rental through a website or mobile app. Short-term rental means a dwelling or dwelling unit that is rented, leased, or otherwise assigned for a tenancy of less than 30 consecutive days' duration where no meals are served. One structure may contain multiple units that are rented, leased, or otherwise assigned for a tenancy of less than 30 consecutive days' duration where no meals are served. Each separate unit shall be considered an individual short-term rental. Prior to January 1st, 2023, short-term rentals include a suite, room, or rooms charged by all persons, companies, corporations, or other like or similar persons, groups, or organizations doing business as motor courts, motels, hotels, inns, or like or similar accommodations businesses. Effective January 1st, 2023, short-term rentals include a suite, room, rooms, cabins, lodgings, campsites, or other accommodations charged by any hotel, motel, inn, tourist camp, tourist cabin, campgrounds, recreational vehicle parks, or any other place in which accommodations are regularly furnished to transients for consideration, or by any person that facilitates the rental of the accommodations by brokering, coordinating, or in any other way arranging for the rental of the accommodations. Short-term rental advertisement means any method of soliciting one of a dwelling unit or portion thereof as a short-term rental. Transient user means a person who exercises occupancy or is entitled to occupancy by reason of concession, permit, right of access, license, or other agreements for a period of less than 30 consecutive days' duration. Section 2. No person, form, or corporation shall own or operate a short-term rental on any premises within Marshall County unless the short-term rental has been registered annually with the Marshall County Treasurer. The Director and/or Marshall County Treasurer may refuse to issue or renew the registration of a short-term rental until all outstanding taxes, penalties, liens, fees, etc., associated with violations of this or any other applicable Marshall County ordinances that have been assessed against the property owner, business, and/or host are paid in full, including occupational taxes. The Director and/or Marshall County Treasurer may deny or refuse to renew the registration of any host for violating or failing to comply with any applicable provision of this or any other applicable Marshall County ordinances. If the property is subject to 2 or more substantiated civil complaints, or the host is found to have twice or violated or failed to comply with any applicable provision of this or any other applicable Marshall County ordinances with respect to a given property within a 12-month period, the Director and/or Marshall County Treasurer may revoke the registration. When a registration is revoked pursuant to this subsection, the owner and host shall be notified of the revocation and shall have 30 days in which to request an appeal before the Marshall County Fiscal Court. If no appeal is requested, the revocation shall become final on the 31st day after the initial action by the Director and/or Marshall County Treasurer. Civil complaints include, but are not limited to, reported violations of building, safety, property maintenance, nuisance, health and sanitation, fire, electrical, plumbing, and mechanical codes. When any owner or host has a short-term rental registration revoked, they shall be ineligible to receive any new short-term rental registrations for a period of 1 calendar year. Section 3, the annual registration, no fee. Each annual registration for a short-term rental shall be per the procedure established by the Director. The registration form at a minimum shall include the following: the name, address, phone number, and email address of the host, and an emergency contact residing or located in Marshall County, Kentucky, and are within 25 miles of the short-term rental, who shall be responsible for addressing any maintenance, safety concerns, or nuisance complaints. The host shall provide the emergency contacts information to transient users upon arriving at the short-term rental. Proof of registration in good standing within the Marshall County Tourist Commission, the location of the short-term rental, and a registration shall expire 1 year from the date it is issued and shall be renewed annually as established by the director. A change in host or ownership of a short-term rental shall invalidate any existing registration. The new host or property owner must apply for registration in his, her, its name. The host is subject to all applicable local taxes, including occupational license taxes, to the Marshall County Fiscal Court. 4, compliance with federal, state, and local laws and regulations. Each separate short-term rental shall at times maintain compliance with any currently applicable laws and regulations of the federal, state, or local governments as may be amended from time to time, including but not limited to laws or regulations regarding non-discrimination, zoning, building, safety, property maintenance, health, sanitation, fire, electrical, plumbing, mechanical, and other applicable laws. 5, transient room taxes to be remitted to the treasurer. Pursuant to ordinance number 23, transient room taxes are to be collected and paid by the host to the Marshall County treasurer. Transient room taxes are ultimately the responsibility of the host, but the collection and remission of all required taxes may be enforced against a housing platform under the KRS Chapter 91A as effective January 1st, 2023, and under ordinance number 23. All hosts and hosting platforms have a joint and several duty to ensure that all transient room taxes are paid as required by this ordinance, ordinance number 23, and KRS Chapter 91A. 6, duties of a host. It shall be the duty of a host under this article to ensure that A, there shall be no more than one contract per short-term rental at a time. B, there shall be no signage or on the premises, of the short-term rental advertising or identifying the short-term rental in residential zoning districts. C, the name, telephone number, and email addresses of the emergency contact as identified in the annual registration shall be conspicuously posted within the short-term rental. And any host using a hosting platform shall include the valid Marshall County treasurer-issued registration number for the short-term rental in the short-term rental advertisement. 7, advertising on a hosting platform. A, short-term rentals registered in accordance with this ordinance may be advertised for short-term stays of less than 30 days on a hosting platform. A host and/or property owner that advertises an unregistered short-term rental on a hosting platform is subject to enforcement as stated in herein. B, the treasurer and/or Marshall County treasurer may request that a hosting platform remove any listing or short-term rental advertisement from the platform where the registration number associated with the short-term rental listing is invalid, expired, or has been revoked. The director and/or Marshall County treasurer shall identify the listing or listings to be removed by the listing URL and displayed registration number, whether valid or invalid, and state the reason for removal. The hosting platform shall remove the listing within 10 business days of notification by the director and/or Marshall County treasurer. The director and/or Marshall County treasurer may request that a hosting platform provide the following information on a monthly basis: the total number of short-term rentals in Marshall County that were listed on the platform during the applicable reporting period, and the total number of nights all short-term rental units were rented through the platform during the applicable reporting period. When requested, these reports shall be due on the last day of each month and shall include information from the preceding month. Example, on June 30th, the May report shall be due. Compliance timeline. All parties subject to the provisions of this ordinance shall achieve compliance within 90 days of its passage and publication. enforcement, and penalties, in addition to any other penalties and interests set forth herein, any person, businesses, corporation, firm, or other entity subject to the transient room tax who fails or refuses to file the required return and/or pay the tax due thereunder shall be subject to the following enforcement remedies. Any entity becoming more than 30 days delinquent shall be subject to civil action for the enforcement of this ordinance and collection of the transient room tax imposed herein. A lien is granted unto the MCTC and/or the Marshall County Fiscal Court upon all property, real or personal, of any person, business, corporation, firm, or other entity subject to the transient room tax to secure the unpaid tax receipts due from said entity. The lien shall be perfected by filing a notice of tax overdue and statement of lien in the Marshall County Court Clerk's office, describing the property on which the lien is asserted. Intentional failure to file the required return and/or pay the tax due thereunder shall be subject criminal penalties of a fine of up to $500 for each month's failure to comply with the ordinance. Waiver of penalties and interest may be granted in the same manner and under the same procedures as provided in ordinance number 23, section 2. If any section, subsection, paragraph, sentence, clause, phrase, or a portion of this ordinance is declared illegal or unconstitutional or otherwise invalid, such declaration shall not affect the remaining portions hereof. Section 3. All ordinances or parts of ordinances in conflict with this ordinance are hereby repealed, including ordinance 2019-07.
Okay, I feel like everybody needs to take a breath.
I'm a little woozy.
I will say, this
Yeah.
type of ordinance is standard, it's becoming standard practice all across the state. So we actually modeled our ordinance after Georgetown, Kentucky. I know a lot of fellow CBBs are doing very similar things. So it's a lot of words, but essentially it just allows us to kind of keep track.
So, a couple of things, just because it's been a little while before, or since you brought this first, and since now we have this reading, and for the new folks who may or may not have watched a couple of those meetings, a couple of key points to me were, again, explain, and to the folks who are watching that may fit within this, the campground piece of this, or the
Yes.
campsite.
So previously, before House Bill 8, campgrounds were, they were not required to collect any local transient tax. But the legislator decided to make that necessary change. And so starting January 1st, campsite rentals that are anything less than 30 days. So it's strictly transient camping. So a lot of our private campgrounds along Kentucky Lake do offer seasonal sites. So if your camper is set up there for more than 30 consecutive days, it is not applicable to the local transient tax. So it's anything that is less than 30 days. You will be required to now collect the 3% local transient tax, as well as the 1% transient tax that goes to the state. And then the 6% sales tax. So essentially now campsite rentals, transient, are treated the same as a motel room or a cabin rental or a private home rental, like on Airbnb.
Okay. So that's key, less than 30 days, because a lot of our campsites, I think, are over that 30 days. But there are some that'll be under that. And then the other big change, of course, is that it now falls to the hosting platform.
Yes,
To
and this,
VRBO and
if
whatever,
you-
Expedia.
If you now list your property on a platform such as Airbnb, VRBO, Evolve, those are the top three, it is the liability to collect and remit the local transient tax is now falling on that platform. Now, do we expect this to be a smooth process? No, we don't, not at all. So we have actually had Evolve has actually already begun to do this, so which has actually, I feel like, gone fairly smoothly. So they remit a list of the properties that they represent, and they just remit one check on behalf of all of their property owners. We've had a Zoom call with VRBO. They have enlisted Avalara Tax Manager to collect and remit all the local transient tax for property owners that are listed on their platforms. And it'll essentially kind of be the same thing. We'll receive sort of a total amount. We are losing, which is part of the reason why this registration piece in this ordinance is kind of important, because we are losing a section of documentation. So right now, if you're an individual property owner and you're collecting and you're remitting that local transient tax, you're sending in that form. So we know your property, we know who you are, but now that it's falling onto the platform because of privacy laws and their corporations, we're losing access to that information. So we will no longer know who the property owner is. We won't necessarily know the address anymore of the property. We're just going to receive a lump sum saying these are all the properties that we represent in Marshall County.
So there's really no way to check.
Yeah, so it's going to be, we gain some in one area, but then we lose something in another area. So that's why we felt like it was important to keep this registration piece in play, just so that we can kind of maintain that relationship, and so that we know at a local level who is utilizing the platforms and who is actively renting. Now, I will say, if you are renting out your property off books, if you are renting it out to friends and family, if you are not utilizing the platform for every single time you rent it out, it falls on you, the property owner, to submit that on the month that you do it. You don't have to submit it every time, but if you choose to do something outside of the platform, then that does fall back on you to make sure that you remit that. I could keep talking, but does that answer the question?
And then the other thing that, just as listening through with this, it is not, for those who are watching too, it's not our responsibility, your responsibility, or ours to check the restrictions of the subdivision that you are in to say whether it is even allowable.
Yeah,
that is your responsibility as a
property owner. Yes, and that's part of the reason why some of those, you can't have big signage out there that says that you're, a private rental, because a lot of these homes are in residential communities. So if that's where your property is, then yes, I would advise that you check with your HOA or whoever, and just make sure that there are no restrictions. Or that it's, okay to be doing that in those areas. So.
And there has been litigation in Marshall County over neighborhood restriction zoning, not zoning, but neighborhood restrictions.
Just because you don't have an HOA does not mean that those restrictions cannot be enforced.
Correct.
It's just, that's at least a governing body, and as you know, and y'all know, that there are very few HOAs, a lot of subdivisions, but very few HOAs along with those. So it's really on, are you going to get sued or not? Once one person brings it up and sues, then it's everybody's playing by the same. Okay.
Okay, before Andy entertains everyone with the reading of 2023-02, I just want to let you know, in Section 1, there's going to be a long definition of who's subject to this. That I literally copied and pasted that from the statute. So that's straight out of KRS. This is not I can't take credit for all that. And then Section 2, I worked with Erica and with Elena on waiver of penalty and interest section, and this is, Erica found one in Jefferson County, right? Found a similar provisions that Jefferson County uses, and I took that and tweaked it a little bit, and so that's up for your consideration as well.
Thank you for all your work on these, Jason.
Yes, sir.
Okay, so this is first reading of ordinance 2023-02, an ordinance establishing transient room tax and enforcement provisions. Whereas the Marshall County Fiscal Court does wish to amend and repeal Ordinance 2013-08 to reflect recent changes to KRS Chapter 91A by the General Assembly. Now therefore, be it ordained by the Fiscal Court of Marshall County as follows. Section 1. It is hereby created a commission to be known as the Marshall County Tourist Commission, DBA Kentucky Lake Convention and Visitors Bureau, MCTC, pursuant to KRS Chapter 91A. The MCTC shall be governed by a board, membership of which is governed and determined by KRS Chapter 91A. Members currently serving pursuant to prior appointments under Ordinance 2013-08 shall remain as members through their current terms and are eligible for reappointment according to statute. The board is vested with all powers and authority granted to it by statute or regulation and is also subject to all statutory and or regulatory duties and requirements of state or federal law. 1. Imposition of a transient room tax. For the purpose of operation of the MCTC and to finance the cost of acquisition, construction, operation, and maintenance of facilities useful in the attraction and promotion of tourist and convention businesses, there is hereby imposed and levied a transient room tax of 3% as authorized by KRS Chapter 91A. Prior to January 1st, 2023, every person, company, corporation, or other like or similar groups, persons, groups, organizations doing business as motor courts, motels, hotels, inns, short-term rentals, or like or similar accommodations businesses in the county shall pay monthly to the Marshall County Treasurer a transient room tax of 3% of the gross rent for every occupancy of a suite, room, or rooms charged and collected by them during such monthly periods. Effective January 1st, 2023, every person, company, corporation, or other like or similar persons, groups, organizations providing occupancy of a suite, room, rooms, cabins, lodgings, campsites, or other accommodations charged by any hotel, motel, inn, tourist camp, tourist cabin, campgrounds, recreational vehicle parks, or any other place by which accommodations are regularly furnished to transients for consideration, or by any person that facilitates the rental of the accommodations by brokering, coordinating, or in any other way arranging for the rental of the accommodations shall pay monthly to the Marshall County Treasurer a transient room tax of 3% of the gross rent for every occupancy of a suite, room, or rooms charged and collected by them during such monthly periods. Such tax shall be due and payable 20 days after the last day of the month, together with the return on a form furnished by or obtained from the MCTC and or the Marshall County Treasurer, setting forth an aggregate amount of gross rentals charged and collected during the occupancy to which the transient room tax applies. Therefore, with such other pertinent information as the MCTC and or Marshall County Treasurer may require. Any tax imposed by this section shall remain unpaid after it becomes due as set forth herein, shall have added to it a penalty of 1.5%, together with interest at a rate of 0.5% for each month of delinquency or fraction thereof until paid. Further, any person or businesses who shall fail, neglect, or refuse to properly complete and file a return as required herein, or pay the tax imposed herein, or any portion thereof, shall be subject to the penalties set forth herein. Transient room taxes shall not apply to the rental or leasing of an apartment supplied by an individual or business that regularly holds itself out of as exclusively providing apartments. Apartment means a room or set of rooms in an apartment building fitted especially with a kitchen and usually leased as a dwelling for a minimum period of 30 days or more. The tax imposed by this section shall be in addition to other general taxes and the occupation or business license tax. The transient room taxes established by this ordinance shall apply to all short-term rentals as regulated and set forth in Ordinance 22. The MCTC and/or the Marshall County Treasurer or any agent or employee designated in writing by same is authorized to examine the books, papers, and records of any facility subject to this ordinance in order to determine the accuracy of any return made, or if no return was made, to ascertain the amount of tax imposed by the terms of this ordinance. Each facility subject to this ordinance is hereby directed and required to give the MCTC and/or the Marshall County Treasurer or its duly authorized agent or employee the means, facilities, and opportunity for examination and investigation as authorized. It shall not be a defense for failure to remit the taxes owed pursuant to this ordinance that insufficient funds were collected from the transients renting the spaces in question, nor shall it be a defense that a third-party hosting platform failed to either collect or remit the taxes due under this ordinance. The MCTC and/or the Marshall County Fiscal Court reserves the right to take collection and enforcement action against any and all entities it reasonably believes is engaged in the activities described in Section 1 above. 2. Penalties. Any person who shall knowingly file a false or fraudulent return required by this ordinance shall, upon conviction, be fined not more than $100 or imprisoned not more than 30 days, or both such fine and imprisonment. In addition to the penalties and interest set forth herein, any person, business, corporation, firm, or other entity subject to the transient room tax who fails or refuses to file the required return and/or pay the tax due thereunder shall be subject to the following enforcement remedies. Any entity becoming more than 30 days delinquent shall be subject to civil action for the enforcement of this ordinance and collection of the transient room tax imposed herein. A lien is granted unto the MCTC and/or the Marshall County Fiscal Court upon all property, real or personal, of any kind, business, corporation, firm, or any other entity subject to the transient room tax to secure the unpaid tax receipts due from said entity. The lien shall be perfected by filing a notice of tax due and statement of lien in the Marshall County Fiscal Clerk's office describing the property on which the lien is asserted. Intentional failure to file the required return and/or pay the tax due thereunder shall be subject criminal penalties of a fine of up to $500 for each month's failure to comply with this ordinance. Section 2. Waiver of penalty or interest. The MCTC shall have the authority to resolve transient room controversies to the extent of waiving penalty or interest, or both, in whole or part, due to responsible cause and not willing or willful neglect. In exercising such authority, the MCTC shall consider the facts and circumstances of each particular matter and the hazards and costs of litigation. The MCTC has no authority to waive any tax due. Reasonable cause exists if the taxpayer establishes that either A, there were significant mitigating factors for the failure, or B, the failure arose as a result of an event, happening, or circumstance entirely beyond the knowledge or control of the taxpayer of the tax due. Events which will be generally considered beyond the taxpayer's knowledge or control include, but are not limited to, the following: unavoidable absence. The absence, example, due to death or serious illness, of the person with the sole responsibility for filing the return in issue or for payment of the tax. The duration of the absence and its proximity to the due date of the return or payment will be taken into consideration. Unavailability of relevant business records. Necessary business records must have been unavailable under such condition in such matter and for such period as to prevent timely compliance. The taxpayer may show that the failure to comply was due to the taxpayer's reasonable reliance on erroneous information provided by an unauthorized employee or agent of the Marshall County Fiscal Court or the MCTC. This exception will not apply if all the relevant facts were not provided by the taxpayer. The erroneous advice must have been provided in writing or be acknowledged in writing by the MCTC or Marshall County Fiscal Court. Any and all factors and circumstances that may exist which affect collectability of the penalties and interest. Events which will not generally be considered as established reasonable cause include, but are not limited to, the following: actions of agent or employee, the filing of a tax return, and the payment of tax due are both personal, non-delegable duties of the taxpayer. Reasonable cause is not established by merely showing that the taxpayer relied upon an employee, accountant, attorney, payroll service, or other person who failed to file the return or pay the tax. Ignorance of the law. Neither ignorance of the law nor ignorance of the necessity of filing a return or paying the tax is sufficient in and of itself to relieve the taxpayer from liability for penalty or interest. No tax forms. Failure to receive or obtain tax forms. In addition to establishing that an event beyond the taxpayer's knowledge or control that caused the failure to file or pay timely, the taxpayer must also establish that the taxpayer acted in a responsible manner both before and after the failure occurred. The taxpayer must demonstrate that the taxpayer undertook appropriate steps to avoid or mitigate the failure, and that the taxpayer rectified the failure as promptly as possible once the impediment to compliance was removed or the failure discovered. In considering requests for waiver of interest and penalties, the MCTC shall take into action the history, if any, of the taxpayer in complying with its obligations in the past. Other evidence demonstrating a lack of willful neglect on the part of the taxpayer with respect to the taxpayer's failure to comply shall also be considered. In order to obtain a waiver of penalty or interest, the taxpayer must submit to the MCTC a written request for the waiver no later than 180 days after notice of assessment of the penalty or interest. In such a request, the taxpayer shall set forth all of the facts and circumstances believed by the taxpayer to constitute reasonable cause for the noncompliance part of the taxpayer giving rise to the penalty or interest. Such a request must be signed by the taxpayer and contain a declaration that is made under the penalties of perjury. The taxpayer should also submit to the MCTC all documentation, affidavits, and other material the taxpayer deems necessary or relevant in support of the taxpayer's position. The MCTC will not generally consider a request for waiver of interest or penalty unless the taxpayer has paid all of the tax to which the interest or penalty relates before or at the time as the taxpayer submits the request. Section 3. If any section, subsection, paragraph, sentence, clause, phrase, or a portion of this ordinance is declared illegal or unconstitutional or otherwise invalid, such declaration shall not affect the remaining portions hereof. Section 4. All ordinances or parts of ordinances in conflict with this ordinance are hereby repealed, including Ordinance 2013-08 and any amendments hereto.
Thank you.
You're
Welcome.
welcome.
Okay, hang on.
Eric,
Of course,
I just want to say,
you know that.
Erica and Elena were very, very, very helpful to me in getting that together, so thank you.
Anytime.
The fine amount, was that taken from Jefferson County as well, or we just come up with a,
That was existing, right? Same-
was it
Yeah,
existing? Okay,
As far as the penalties and interests, yeah, that's what
And
the
the-
current ordinance was.
okay. So question on, okay, Section 2, under 3, which is the waiver of penalty or interest. Help me to read that to me where it makes sense, where it doesn't say, it says shall have the authority, and then it feels like the last sentence says has no authority to waive the
It's
tax.
the tax due, so this
The
is talking
tax
about the penalties
owed.
and interest portion of it. So they have the tax, they have the penalties and the interest. This is a waiver for the penalties and interest, not the
Only.
tax based on rental usage.
Yeah, we don't have the authority to say they don't have to pay the actual transient tax, but we can work with them if there was extenuating circumstances to waive the penalties and interest.
Or interest, okay.
It's just like on real property taxes.
Okay.
There are
Gotcha.
certain provisions in the statute that allow for waiver of penalties and interest on property taxes, but the actual tax due, there's no wiggle room there.
So I know this doesn't come up very often in real estate transactions. I mean, obviously, real estate tax is something that all attorneys and title companies think we collect, prorate, all that kind of stuff. This particular tax, this ordinance doesn't change that to where that's simply if it's in real estate, the realtor has to think of, should I collect what's due currently on that property? You know what I'm saying? I mean, there's no way without a lien being filed, there's no way to find what this amount is other than to think about it at that time and contact her or the treasurer's office. Okay. So it's just
They would
something,
have the information.
maybe something that we need to discuss on the local realtor level, just to remember that. They don't have very many.
I will say, it was the previous courts, when we were discussing this earlier, that it was going to fall on the CVB, the MCTC, to actually enforce the ordinance as far as delinquencies and penalties and interest, to alleviate some of the pressure off the treasurer's office. So I think the process itself will stay the same. We'll get the forms out to them. They'll remit it to the treasurer's office. She'll open it and record it as necessary. But in order for us to successfully, and I think to try to keep track of those delinquencies as they come up, it probably would be helpful if our office actually stored and had the actual physical returns. So if there's no objection to that, like after the fact, after the 20th, because transient tax is always due the 20th of the following month. So after the 20th happens, I'll have my bookkeeper come up and actually collect the physical returns so that we can sort of monitor and that way, if we do come across any delinquencies, we can stay on top of it so it doesn't get too far behind. If there's no opposition to that.
What's your?
I don't have any objection to that, other than as a fiscal court, we are the record keepers of that. So we have to keep a record in some way
So,
of that. We do have
copy-
Laserfish.
Copies, yeah.
Copies, not
Yeah,
actual
and we would
return.
issue- Yeah.
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 All right.
Absolutely.
Okay. All right. Thank you.
Thank you.
Thanks. Now, go number by number through your
Okay.
tax, through your budget.
Ordinance 2023-3, budget amendment. Erica, if you'd read that, please.
Ordinance 2023-03, an ordinance relating to the annual budget and amendment thereof, whereas the County of Marshall has received additional funds. Now be it ordained by the Fiscal Court of Marshall County that Section 1, the annual budget for fiscal year 2022-2023 is amended to A, increase the following revenue accounts. Sheriff cash balance July 1, $122,900. Contract with other counties, $90,000. Jail cash balance July 1, $110,000. Occupational tax cash balance July 1, $200,000, for a total increase of revenue accounts of $522,900. B, increase expenditure accounts as follows: Sheriff deputy expenses Wi-Fi jetpacks, $9,000. Sheriff office expenses office supplies, $8,000. Sheriff's auto expenses, new car leases, $80,000. Sheriff's auto expenses repairs, $10,000. Sheriff's out-of-county travel and training, $5,000. Sheriff's office fuel, $10,900. Occupational tax reserves, $200,000. Jail reserves, $200,000, for a total increase of expenditure accounts of $522,900. Section 2, the amounts added to the revenue and expenditure accounts in Section 1 are for governmental purposes, approved by the Marshall County Fiscal Court the third day of January 2023. Kevin Spraggs, County Judge Executive.
That was our first reading, requires no action. Next up is Sheriff Hilbrecht.
Do we move for a short recess before we get started on that?
Second.
All those in favor?
Aye. Run.
Okay, we'll call the meeting back to order. Next, we have Sheriff Hilbrecht's 2023 annual order setting maximum amount of salaries for deputies and assistants. Commissioners, I think you all have had this in front of you. Does anyone have any questions for him at this time?
Make a motion to approve the annual order setting maximum salaries for deputies and assistants.
Do I have a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Motion carries. And the sheriff's 2023 budget. Once again, you've had that. Does anyone have any questions for him on that?
Motion to approve the budget.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Motion carries. And we've got time for one more, and then we're going to have to go into executive session. I'd like to present my appointments. Andrew Pagel, Deputy Judge. He's been reading all of our ordinances for us. We appreciate him very much. And Kurt Kurtner. Hey, Kurt, if you don't mind, if you'd step up for just a second, I'd just like very briefly for you to discuss the code red, just share that information with those that are going to be watching if they're not signed up for that, and explain to them that it does not necessarily go out to the entire county. It's area specific.
Okay, so glad to be back. Thank you for the appointment, Judge. Discussing the code red last night was a fine example of why everybody needs to sign up for this. It's another safety for you to get warnings for bad weather. We played tornado chase on and off for a couple hours last night. But if you'll go to Marshall County Fiscal Court website and go to the very bottom, there's a link that says Code Red. It's self-explanatory. If you have any issues trying to sign up for it, just call the Office of Emergency Management. That number's listed on the website also. We'll get you through that. A lot of people think because they signed up for it that they're not getting the warnings. It's pretty much site-specific. Your address, if it comes into a certain area for a warning, you will get that. You won't get it if you live in Hardin and there's a warning for possum trot, okay? It's not going to set it off for everybody. It's not like a county siren that just goes off for the whole county. Code Red's a good asset, a great tool. And like I said, we need to do that, get everybody signed up. There's no charge to it whatsoever for the citizens. The fiscal court pays that fee, so moving forward, please sign up for it.
Thank you.
I think the other key, too, to remind folks is that we changed those sirens to only go off for tornado warnings, right?
That's what I was told,
Yeah.
and we've got some deficiencies. I've got a lot of calls in the middle of the night because they're not going off. I've got to find out who's responsible for the maintenance on them and why some are working and some aren't as we speak.
Okay.
Well, the one at the Harvey Fire Station was working fine last night because it went off twice, both times when each tornado warning was issued, so.
And I'm back in the saddle again, but I got to get back in the loop and see what we got going on. So, but we'll get there. Okay.
He looks tired. He is. He's up all night. I know that because I was communicating with him.
Well, last night, yeah, like I said, tornadoes, truck wreck off the interstate, missing juvenile, a house fire shut down Highway 68. Hey, another day in the neighborhood, right?
Thank you, Kurt.
Thank you.
Okay, one more here. Our road superintendent appointment, Roy Watkins, for a 4-year term. I can't say enough good things about this gentleman, working with him the 4 years I've served as commissioner. Our road department is top-notch. in the state of Kentucky or in the United States for that matter. They do an awesome, awesome job. And, appreciate everything they do. With that said, do I have a motion to appoint Roy for another 4-year term?
Yeah, I move to approve Road Superintendent Roy Wadkins, 4-year appointment effective 1/10/2023 per KRS 179.020-7.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Aye. Motion carries.
Unanimous, Roy.
Do you want,
No
you
pressure.
want any of the
bro.
other
Don't
ones?
let that go to your head. Okay, let's see here. We need a motion to go into executive session to discuss personnel and litigation per KRS 61.810, 1C and F.
So moved.
Second. Any discussion? All in favor?
Aye.
Motion carries. Call Marshall County Fiscal Court back to order. Next item on the agenda is the deputy judge and judge's office staff approval of position and compensation.
All right.
Motion for that, please.
I make a motion to approve the judge's office new hire Brad Warning effective 1/3/2023 at $36.44 an hour.
Second.
Any discussion? All in favor? Motion passes. Brad has been gracious enough to stay on as transitional and for a few months to help us out, and we appreciate that. The next item, the deputy judge and judge, well, wait a minute here. Just get that. Let me back up. Need our 2023 active employee approval. We'll need a motion for that, please.
Where's that one?
K.
Wait a minute. K's
K?
the first one, yeah.
Oh, sorry. Let me back up here. Get back in the groove here in a minute. Deputy Judge and Judge's Office staff approval of position and compensation.
All right, so I move to approve the deputy judge and office personnel of the judge executive per KRS 67.711. And we need to approve the compensation as well, but I don't have those.
I bet Erica does.
So that's deputy judge and fiscal court clerk and. Okay. Well, I've already done Brad's.
Yeah, you've done
Right,
Brad.
separately.
Okay, so Corin Daniel is $16.87 per hour. Brad Warning, we've just read off, that is $36.44 per hour. And Andrew Pagel is $65,000 annual salary.
Okay. Make that motion with those compensations added to it.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Aye.
Motion carries. 2023 active employee approval.
Okay, so I move to approve the Marshall County Fiscal Court's active employees.
Have a second?
Second.
Discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion carries. Next item, orders, bond, and oath of coroner, jailer, constables, sheriff, and judge executive.
Okay.
A separate motion for each, please.
I think I have these. Motion to approve the order of bond and oath of the coroner per KRS 72.010.
Second?
Second.
Any discussion? All those in favor?
Aye.
Motion carries.
Move to approve order of bond and oath of the constables per KRS 70.310.
Second.
Any discussion? All those in favor?
Aye.
Motion carries.
Move to approve the order of bond and oath of the jailer per KRS 71.010.
Second.
Any discussion? All those in favor?
Aye.
Motion carries.
Move to approve the order of bond and oath of the sheriff per KRS 70.020.
Is there a second?
Second. I had to think about that one.
Making him sweat there a minute. Any discussion? All those in favor?
Aye.
Motion carries.
Now, we definitely want him to be bonded.
Yeah.
This is not his pay.
Oh, yeah.
Move to approve the order of bond and oath of the judge executive per KRS 67.720.
Second.
Any discussion? All those in favor?
Aye.
Motion carries. Board appointment. The first one we have is for Fair Dealing Olive Fire District, and that is Stuart Rake. Is that correct? I think it's Rakey. Rakey? Rakey. Apologize for that. He's actually replacing Jason Bradley's term, who's moved up to chief. That term will be set to expire 6/30/2025. Do I have a motion?
So moved.
Second.
Any discussion?
Yeah, I was gonna say, I called and talked to him and seemed like he's excited about it, and Matt think he was a good guy, so I think maybe it'd be a good fit.
Very good. All those in favor?
Aye.
Motion carries. We have an appointment for Kentucky Lake Convention and Visitors Bureau of Kimberly Lightfoot, the term to expire December 31st of '25.
And just to reiterate, go back to what we were discussing then, she had been appointed, and it was just, unfortunately, we just had the past person's name, and that was the confusion from the last. So this is truly a reappointment of her. We just had her predecessor's name in there. So I move to approve.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Motion carries. Bank account signers change will be Erica.
Okay, we just do the minutes to reflect that we need new signers on the fiscal court bank accounts. The new signers need to be Kevin Spraggs, Erica West, and Andrew Pagel.
So move.
Second.
Any discussion? All those in favor?
Aye.
Motion carries. Motion to approve Roger Ford's training incentive.
So moved.
Second?
Second.
Any discussion? All those in favor?
Aye.
Aye.
Motion carries. Asking for a motion to authorize Roy, the road department, to advertise for applicants to replace a retired employee.
So move.
Second.
Any discussion? All in favor?
Aye.
Motion carries. Transfers?
I have bank transfers. I have occupational tax transfers to the funds that are subsidized with OTA. So there's one to the general fund of $100,000, to the road fund of $100,000, to the jail fund of $75,000, to 911 fund of $75,000, and to the sheriff fund, which lives in the general fund bank account, for $100,000. There's also a transient tax bank transfer that needs to be made. It's $18,538.64.
Move we approve the bank transfers.
Second.
Any discussion? All those in favor?
Aye.
Motion carries. Do I have a motion to pay the bills?
So moved.
Second.
Any discussion? All those in favor?
Aye.
Motion carries.
Just out of curiosity, so did you have to, now that we're past the first of the year, do you have to send something in as far as the 65-35 verification, or how do you?
No, to my knowledge, I do not.
Okay.
I assume it only
It's
comes
something
up if
that-
that's, if for some reason they want to investigate that. But I've kept an eye on that, and with our last budget amendment, we only had one fund that was the donation fund that was nearing that border. And our last budget amendment took care of that.
Okay.
Do I have a motion to recess until 1 o'clock?
Well, Mr. Concrete, your hearing was set for 1. We're done with business. Were you ready to go now? Does the court want a 15-minute break, or you just want to keep going?
Let's roll.
Ready?
Yep.
All right. All right, Mr. Concrete, you're free to sit there or approach the podium if you want to. So what I'm going to do, first of all, is update the court on what has transpired since the January 2020 hearing, in which Mr. Concrete was trespassed from Marsh County Parks for a period of 3 years. That trespass period is up at the end of this week, so this is a hearing to determine whether or not his ban from Marsh County Parks will continue beyond that 3-year period. So that's what we're here on. So prior to the criminal mischief trial of Mr. Concrete on January 28, 2022, which when that trial took place, he was afforded the opportunity to have his prohibition from entering the park lifted and charges dismissed if he would simply sign an agreement stating that he would follow the rules of the park. He declined to sign this agreement and insisted on going to a trial. At the criminal trial, the evidence presented to the jury included, but was not limited to, the following. Jessica Treese, a current 911 dispatcher and former employee of the Marsh County Park System, testified that on November 4th, 2019, she observed Mr. Concrete inside Miller Park standing near a running water spigot at closing time around 10 p.m. Treese stated that Mr. Concrete stood there for approximately 7 to 8 minutes with the water running, and that you were not using any of the water for any purpose. Treese stated that when Mr. Concrete saw her, he took off running away from her. Treese stated on the morning of November 10th, 2019, she reported to Miller Park as part of her routine duties and observed that multiple water spigots had been turned on and left running all night, causing flooding at various areas within the park. Treese testified that all the spigots were running wide open when she arrived that morning, and flooding was visible around the areas of those spigots. Treese authenticated 2 photographs she took that morning depicting the flooding near the entrance to the park, which were introduced as Commonwealth's Exhibit 1 and 2. Treese affirmatively testified that the flooding was not due to normal morning dew and that there had been no rain the night before or that morning. Therefore, the areas near the spigots were the only areas that had been flooded. Brittany Hargrove, director of Marsh County Parks, also testified at the trial. Hargrove stated that she also observed the 2 exhibit photographs regarding the flooding. She also testified extensively as to the problems that this either caused the park or could have caused the park, which include the following. Soil and grass erosion around the areas being flooded, inability to properly maintain those areas with routine groundskeeping, water wasted and the accompanying money wasted from the park having to pay for that wasted water, inherent damage caused to the pavement from running water, the dangers of water freezing for both pedestrian and vehicle traffic, because this had occurred in late November, and dangers to both people and property due to the soaked grass and grounds, because at this particular time the park staff was installing Christmas lights with electrical wiring all over the park. The last witness to testify was Sheriff Matt Hilbrick of the Sheriff's Office. He stated that he conducted an interview with Mr. Concrete regarding the allegations made against him. The sheriff testified that he unequivocally admitted that he was the individual who had both turned the water spigots on and left them running. He also stated that Mr. Concrete had admitted to doing this multiple times, and at no point during the interview did he deny that he was the person responsible for these acts. Sheriff Hilbrick also stated that Mr. Concrete told him that it was not his responsibility to turn the water off since he was not an employee of the park. Sheriff Hilbrick also testified that at one point, Mr. Concrete asked Mr. Concrete if he would just simply agree to cease this behavior and simply stop leaving the spigots running continuously. Per Sheriff Hilbrick's testimony, which was a recorded interview, Mr. Concrete stated that he would not agree to do so. Upon hearing this evidence, the jury convicted Mr. Concrete of criminal mischief third degree, a Class B misdemeanor for his criminal acts in the park. The Marshall District Court then placed certain conditions upon him as part of his sentence, which he is still under to this day. One of those conditions is he is not to be on any park property as ordered by the Marshall County Fiscal Court. Since that time, he filed an appeal of his criminal conviction, which was denied, and then also filed a request for the Court of Appeals to hear his case, which was also denied. Mr. Concrete has furthermore continued to post videos on YouTube, one which refers to Brittany Hargrove as 007 Park Boss, degrading interviews toward Ms. Hargrove. In short, for the past several years, Mr. Concrete has basically shown no remorse for his actions, nor has he shown any willingness that he would abide by park rules, even if given access. In addition, park staff continue to state to this day that they do not feel safe or comfortable with him having access to the park. So that's an update of what's transpired since our last hearing. So, Mr. Concrete, now it's your opportunity to speak to the fiscal court.
What rules did I break again?
This is your opportunity to speak to the fiscal court.
Mr. Darnell, I didn't break any rules at this park.
You were convicted of a misdemeanor.
It's my turn to talk, I thought you said?
You asked me a question.
Yeah, but
You
you
were
said my turn
convicted
to
of a
talk.
misdemeanor for vandalism in the county park.
I was.
Yes,
Yeah, in district court?
yes.
Oh, yeah, you proved that I was at the county park. Good job. Proud of you.
The jury convicted you, Mr. Concrete.
I asked Brad Warning last week for a complaint form. I didn't get a complaint form. Is there a complaint form available for county employees?
This is your time to speak
I'm
to the
asking
fiscal
Mr.
court.
Spraggs, not you.
Okay.
Mr. Spraggs, is there a complaint form for employees?
I'm going to refer that to Jason.
Jason, is there a complaint form for county employees? I've looked on the website. The only thing I can find is E911 complaint forms. I'm looking for just an employee complaint form.
Do you understand why you're here?
I'm here requesting a complaint form, Jason.
No, you're here to request, if you're asking to be allowed back on park property. Is that the reason why you're here?
I was trespassed from the park for 3 years.
Do you want to be back on park property?
I was trespassed from the park for 3 years.
Do you want to be back on park property? Yes or no?
I was trespassed in the park for 3 years.
Okay.
For nothing. Nothing I did wrong.
You were convicted of a crime, Mr. Concrete.
No.
Yes, you were.
You convicted me of being at the park. There is
You
a
were
difference
convicted of
between
a
that
crime.
When you know everybody in the court system, it works out in your favor most of the time. But either way, I was trespassed for 3 years. What more are you going to punish me with for what? Nothing.
You're still under probation.
I still done nothing at the park, though.
You
I
were
went to
convicted.
the park and I
You
followed
were
the rules.
convicted, Mr. Concrete.
I've been
Your
going.
conviction was upheld on appeal twice.
All right, back to the complaint form. I've requested a complaint form.
That has no relevance to this.
Yes, it does.
No, it does not. Move on, move on.
Brittany wrote a email to somebody, says, nope, Dad said he's giving me a gun tonight. Just call me 007 Park Boss with her hand cover. And that means, oops, I took it to the Marshall County Sheriff Department. They refused to
That has no
investigate
relevance
this.
to this case. Move on.
This has all the relevance to do with this case.
The issue is whether or not.
This lady threatened me with a gun. And
Okay,
the court
it's going to
system
be a really,
refused to do anything
it's going to
about
be a really short hearing unless you follow the rules, okay? The issue is whether or not, if you're allowed back on the park property, you will follow park rules.
it. I've already
That's-
followed the park rules.
You were convicted of a crime and it was affirmed.
I've already followed park rules.
Okay, so now is your opportunity to tell the court why they should let you back on park property.
I mean, I'm no more a citizen than anybody else in this county that should be allowed at the park, or anybody else in this country should be allowed at this park. It's a public park. It's open to anybody to come enjoy it. There are no written rules. I've searched and searched for written rules. There are a few written rules, but they're very vague. They don't go in very many detail, but there are no actual rules that I broke of this park. And Jason's going up and over and saying I broke some rules, and there are none. So, yes, I will follow all the rules of the park, just as I always have. I've done it for many years of this park. I've followed the rules for years and years. So, I don't know. I've been trespassed for 3 years for nothing already, and now, what, you want to trespass me some more? I mean, I've been following the rules all my life at that park. I've not ever broke a rule. The only rules I see at this park is no skateboards, no bicycles in the basketball court, and there's a big old list of rules for the splash pad. There is a rule list on the Marshall County website about this park, but none of them rules did I break. There's none of them rules listed that I did anything wrong. In fact, I was there enjoying the park. I go to the park and run, just like you, Jason. We run together, don't we? We enjoy going out and running. But, you know, park's right in my backyard. I can go over any time to run. Safe little area to run. But you keep trespassing me for none of these rules. It's like you're just out to retaliate against me.
Okay, for the 15th time, you were convicted of a misdemeanor crime inside the park. Are you forgetting that?
No.
Okay.
No, I got aware that you convicted me of being at the park for the 15th time. I was at the park at the 15th time. I was enjoying the park. I wasn't breaking any rules at the park.
You committed a crime in the park.
I wasn't committing any crime at the
You
park.
were convicted of a crime.
You got any evidence on that?
It was presented to the
Do you got any
jury,
evidence on
affirmed
that?
on appeal twice.
Do you got any evidence on that?
Yes, it was
Can you
presented
show me
to a
the
Marshall
evidence of the
County
crime?
grand jury.
Can you show the evidence of the crime?
I already did. You were convicted.
I'm still looking for the evidence, though.
You were convicted at trial.
Well, a lot of county attorneys convict people, and it's not true.
You have anything else to say?
No, that's
All right.
it. I just like to, you know, I do have something else to say. I would like a list of the park rules, because the only list I have found is on the website and at the park posted.
We'll get them to you.
What about everybody else, not just me?
You're the one asking for them.
All right.
We'll
And
get
then
'em
I
to
had
you.
one other, I've asked Brad several times about this, gun laws in the park. Used to have a sign that said no
We're
guns.
not talking, that's no relevance to this matter.
It's about the park.
It has no relevance to
It's
this
about a
case.
rule of the park.
Anything else you got to say?
Yes, the rules of the park of the gun laws. Am I allowed to pack my gun in the park?
Anything else you
Is
got to say?
anybody else allowed to pack a
Okay,
gun
we're
in the
done,
park?
we're done, we're done.
Hard to break rules when you're following them. isn't it?
All right, that's it.
Well,
Anything else?
You know, there's all kinds of stuff here, but it'll take a while. I just want some written rules, and I want everybody to follow the rules, not just
We're
pinpoint.
going to get you the rules. We're going to get you the rules.
Not just me. What about everybody else to follow the rules?
You're the one asking, we'll get you the rules.
Well, I don't
Anything
want to
else?
ask for the rules. I
Anything
want
else?
everybody to follow the rules.
Anything else? Anything else?
No?
Okay,
Have a good day.
you too.
We'll see you in the woods.
What does that mean?
We both enjoy the activities outdoors, don't we? I'll see you in the woods.
Is that a threat?
Nope, we don't threat around here. See you in the woods.
Better be really careful what you say, Mr. Conklin.
See you in the woods.
You need a motion?
What's the,
So it's based upon what we've heard, again, he has shown no remorse for any of his actions, nor shown any willingness that he would abide by the park rules if given access. Therefore, it's my recommendation that he be trespassed again until at least the probationary period ends in his criminal case, which will be January 28th, 2024. So he's already on probation. He continues to be on probation through Marshall District Court with a ban through that action. So it makes sense that this court would do the same through at least that time period.
Make a motion to be trespassed until January 28, 2024.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Motion carries.
So at the end of that period, you can once again request to be granted access, and we'll see if you have a change of attitude at that point.
I don't have an attitude, Jason.
Okay. Have a good day.
Yeah.
Do I have a motion to adjourn?
So moved.
Second?
Second.
Any discussion? All those in favor?
Aye.
Motion carries.